Indigenous healing lodges are intended to address the high rate of Indigenous people behind bars and concerns that traditional prison programs don't work well for them. First created in the 90s, there are now 9 such healing lodges across the country, most in the prairies. Corrections Canada says services and programs for offenders use a, quote, holistic and spiritual approach, incorporating Indigenous values, traditions, and beliefs. Elders play a critical role in these spiritual lodges, holding ceremonies and teaching. Offenders learn Indigenous languages and are taught how to live independently for when they get out. And these minimum and medium security facilities aren't limited to Indigenous inmates. Others are free to apply to if they accept the Indigenous programming and spirituality. Corrections Canada says before moving an offender to a healing lodge, it does weigh the risk to public safety. Of the child murderers transferred to healing lodges since 2011, Public Safety says at least 14 of them were in healing lodges under the previous Conservative government. So why is this issue only sparking outrage now? Peter MacKay was Justice Minister from 2013 to 2015. He's now with Baker and McKenzie LLP. Hi, Mr. MacKay. Great to see you again.
Thank you, Vashi. Good to be with you.
Were you surprised, Mr. MacKay, to learn that there were transfers, or maybe you already knew, of people convicted of killing a child from traditional jails to healing lodges under the previous Conservative government's watch?
I was, just as I was surprised to hear that it happened in the McClintock case. Totally inappropriate, and clearly the criteria at Corrections Services Canada was inappropriate then and inappropriate now, and further changes have to be made going forward to ensure the protection of the public.
How do you know that it's clearly inappropriate in the case of, there are 11 people right now being held in these healing lodges, people who are convicted of first or second degree murder of a child. How do you know for certain in those cases that it's inappropriate?
Well, I haven't seen all of the circumstances, and depending on where in the sentence the transfer occurred, I suppose, and how the individual was reacting to incarceration and rehabilitative efforts is part of the criteria, but it has to be a broad criteria. I would suggest that there is a blazing red line when it comes to the transfer of a child killer, especially in the circumstances that we're all aware of, where the child was lured, raped, tortured, and murdered with a hammer. That I don't think that takes any kind of a child psychologist or any sort of an expert in penal reform to suggest that it's not appropriate. If a person is nearing warrant expiry and they're going to be released anyway, it might be considered. But there are still a lot of questions. Was the Native community itself, in this instance, consulted? Have we closed some of the other question marks as to whether individuals have taken steps to reform their own behavior, and are they properly remorseful? Are they still a risk to society? All of those questions have to be front and center when these type of transfers to a minimum security facility occur.
Well, the healing lodges are minimum and medium, from my understanding. And the questions that you're raising, though, I'm wondering if you think that the Liberals, the new rules that they've set up, answer them, because essentially they do tighten the conditions under which someone can be transferred. For example, when you're talking about the stage of the sentence that they're in, their behavior in the correctional institution they're currently in. That stuff is now all going to be taken into account, so much so that Terry McClintock was transferred back.
Right, and so whether it goes far enough remains to be seen. I'm still a bit of a skeptic, given that this did happen, and this is an after-the-fact attempt to sort of deal with that one situation. I still think there has to be a very, very high bar that is set. There is no stronger obligation, responsibility on the part of a government than to protect our most vulnerable citizens. And so it is beyond comprehension that this happened in the first instance. Corrections Services Canada has to do a really deep dive as to how this occurred. And I appreciate the fact that the current government is taking steps now to correct it. They were very reluctant to do so. Ralph Goodale called it a bad practice, what this horrific murder really was. The Prime Minister himself avoided taking part in the debate and the vote, steps outside and accuses the opposition of being ambulance chasers, for being basically a reflection of society's revulsion of this situation. And so, you know...
They also did, though, to be fair, call for a review pretty shortly after the case was first raised, and then
they did.
kept deferring. I take your point about the name calling and stuff like that, but they did call for that review. They conducted the review, and then they did change the rules at the end.
And we're reluctant to meet with Tory Stafford's father. So in any event, that's all ancient
they
history,
did.
water under the bridge. Yeah, they ultimately did. But let's come back to your question, and that is, have we gone far enough in ensuring that we're protecting people in the future from these type of transfers? That facility, Vash, you may know, had an individual who was there serving time for, I believe it was impaired driving causing death, walked away from that facility. So that's the concern. And the fact that there were children present in that facility as well also raises real questions of its appropriateness.
Do you think, though, that Conservatives at all are being a bit hypocritical, criticizing the Liberals so harshly for allowing those kinds of transfers to happen when it did happen under the previous government as well?
Well, I think you come back to the question that you asked me, and that is, was there awareness? Had the media or the opposition raised it at the time, I dare say, given our record on criminal justice reform, whether it was doing away with the faint hope clause, introducing legislation that would mean life means life, a lot of justice reforms around mandatory minimum penalties for violent and sexual violent offenses, I dare say we could have fixed it a long time ago.
But all I did was ask public safety for those numbers. Surely they could have been available to Mr. Scheer and his party if they had just asked prior to deciding to take that line of criticism.
Yes, and good on you for disclosing this. What I'm saying in response to your question is, I only wish that we had known this 10 years ago and taken proper steps to make those changes. Maybe this entire situation and the trauma for the Stafford family and others could have been avoided.
Before I let you go, can I ask you about the process of victims being notified and their families being notified of this, and sort of that being the only way to find out if for example, the case of Terry McClintock, Rodney Stafford had to be notified. There were issues getting a hold of him. He felt, you could tell, very frustrated by that. Do you think that process needs to be looked at more closely? And in your experience, for example, as Minister of Justice, I know you presided over the Victims' Bill of Rights, but do there need to be some improvements on that?
Well, I would just like to see the Victims' Bill of Rights upheld, and I would like to see more adherence by judges, by officials within our justice system, our corrections system, ensuring that people like Mr. Stafford and others, family members, victims themselves, are properly notified. So I think that's where it breaks down. New legislation or tightening the rules may help, but simply respecting the current legislation and ensuring that victims are kept in the loop. Parole hearings is another element of our system where family members are sometimes finding out too late. And so it is being much more vigilant in the enforcement and the respect of the Victims' Bill of Rights that will, I think, go a long way to improving our system.
Victims have to register right now in order to get that information. And my understanding is there was sort of a lack of contact information at the time in the case of Mr. Stafford. Do you think that is it too onerous? That's the kind of thing I'm talking about. Does there need to be improvements around that? Short
answer, Vashi, is yes, there has to be improvements. And it shouldn't have to be proactive on the part of the victim and their families. It should be done by corrections services, and that's a failing on all governments. That is not to point the finger at anyone. I think we are coming up short when it comes to helping victims, and it also has a broader deterrent effect when you are seeing these victims really re-victimized and dragged through a very traumatic experience again. So I would hope that we will learn some hard lessons here and send a stronger message to the general public that the government, all governments, are focused on protecting them and ensuring that they are properly informed. That's something I think that improves people's confidence in the justice system.
Okay, I'll leave it there. Thank you so much, Mr. MacKay. Great to have you back.
Thank you, Vashi.